Pioneer brand canola with Optimum Gly, the highest yielding glyphosate tolerant trait on the market. What's next in canola happens here.
Sean Haney here with Real Ag Radio, Rural Radio 147, Sirius XM, and RealAgriculture.com. Going to talk about a new piece of legislation that if you have cross-border operations, if as a Canadian company in the U.S., or maybe for somebody listening that may be in agriculture in Mexico, operating in the U.S. as well, there's something called the Corporate Transparency Act, the CTA, that may be of concern to you. Here to break it down and talk about what it is and who it impacts is Adam Dunst. He is a partner with Dentons out of New York City. Adam, great to chat with you.
Thanks, Sean, and thanks for having me on the show. Really excited to talk about the CTA with you, and look forward to speaking.
Yeah, not every day probably being a partner in New York. You get to talk to farmers and ranchers across Canada and the U.S., but this is going to be a great opportunity for you.
Sounds like a great audience. Thanks.
Absolutely. Okay, first off, high level, what is the Corporate Transparency Act, and what is it trying to accomplish?
Good question, because it is a confusing topic, and knowing what it's trying to get at really is helpful to help understand. So the Corporate Transparency Act, and more specifically, we're going to be talking, I think, about the Beneficial Ownership Information Reporting Rule under it, or the BOI rule, and we refer to the Corporate Transparency Act as a CTA. That really came into effect at the beginning of 2024, and its objectives, or primary objectives, are to help combat anti-money laundering, tax fraud, and other crimes. Basically, a way of the U.S. government to get at shell companies and get into ownership and try to prevent those bad things from happening. The U.S. had realized that it was ranked pretty high on a bad list, which was a list of secrecy and ownership of companies, and in order to bring it in line with a lot of what jurisdictions around the world are doing, it implemented this law and these rules, which basically covers entities that are either formed in the U.S. By filing, or foreign entities which qualify to do business in the U.S. state by filing documents are subject to the reporting, and that's really beneficial ownership and control reporting.
Is it my understanding here is that, as you described, targeting anti-money, money laundering activities and things like that, but casting a pretty wide net. And so there are people now, or companies, entities that have to disclose or register, and we'll go through what that looks like. And it never even thought about having to potentially do this sort of out of this is sort of out of their normal daily activities in terms of thinking about this kind of stuff. Has this cast a pretty wide net?
It has, Sean. There are a handful, I'd say about 23 exemptions or something like that, but many of them don't apply to entities that are businesses that people otherwise may have thought, they would apply. So, the average client thinks, there must be an exemption for us because this is kind of out of the ordinary, and it really is a revolutionary kind of law that's been implemented. But more often than not, there is no exemption that's directly applicable, whether you're a mom and pop business that's filed an LLC to do business somewhere in the U.S., or you're a cross-border agricultural company. There may or may not be an exemption that applies, but it is a very wide net, and it will capture a lot of companies in that.
Okay, so let's talk about who does this apply to, and how do you determine if you're included or not?
So the first thing to look at is if you have any entity, whether it's an LLC, corporation, or otherwise, and you either formed it in a state in the U.S. or a tribal jurisdiction by filing a document, filing a piece of paper with the Secretary of State, perhaps, or if you have a company or other entity that is not a U.S. company, say a Canadian entity, but you have filed a document to do business, qualify to do business, say in New York, Montana, anywhere in the United States, that entity would be captured. Also, if you're a conglomerate and you have lots of entities and you're based in Canada, but you formed one entity as a sales arm in the United States, somewhere down your corporate chain, that entity would be picked up as well.
Yeah, my understanding is you're a Canadian, it could be like a Canadian company that has a contract to operate, or you have some sort of activity in a U.S. state. Pay attention to some of the language in terms of in that contract, how it refers to abiding by the laws or regulations in that state. You need to be careful of some of the fine print and how some of those contracts are even worded, correct?
Right. Well, if you're looking simply at a contract, contract between two companies, that alone wouldn't pull you into the CTA. But if you are talking about, an LLC agreement, say for a joint venture, and the Canadian entity maybe formed with a U.S. entity, a joint venture, and you formed it in Delaware, or any state in the United States, then you're going to be, pulled into that. And if you're merely an owner, a beneficial owner of a business that's subject to reporting, then again, you can get pulled in by, being a substantial owner or substantial control person of that business.
So what are the reporting requirements?
So it's another good question. The company itself would have to report, and that includes reporting the company's full legal name, the company's address, where its principal place of business in the United States is, the company's IRS number, and then the company would have to report, which of its direct or indirect human beneficial owners own 25% more of the company's equity or have exercised substantial control over the company. And we could talk about that in a minute as well. But then when you get those individuals, you have to list those individuals' full names, their addresses. You have to get unique identification numbers from government in respect to those individuals. Could be on their passports or on their driver's licenses, and then copies of those identification documents also have to be submitted.
And the timelines here, this came into effect January 1st of 2024, is that correct?
Correct. And so there's a few different timelines that apply. For entities formed before 2024, you have basically until January 1st, 2025 to file, your reports to comply. For any entities that were formed in 2024, you had 90 days from the date of formation. And going forward in 2025 and thereafter, you'll have 30 days to file your report. Then there's also anytime any of the information changes that should be picked up on the report, you have 30 days to file an amendment to the report. So that would cover changes in ownership, that potentially changes in, CEO. Lots of different changes can trigger those updates.
And who am I filing with again? Is that the Treasury Department, or who am I doing that with?
Yeah. Treasury Department, specifically the Financial Crimes Enforcement Network, otherwise, commonly referred to as FinCEN, and then they're part of the Treasury Network. Treasury.
Now, I was in a meeting where I was first exposed to the CTA, and I was listening, and okay, yeah. And then I heard the penalties. And then I was like, whoa, pretty substantial financial penalties for non-compliance. And even jail time was mentioned as one of the consequences. So talk about some of the penalties here. This will grab the audience's attention for sure.
Yeah, so is another really good point. There are both civil and criminal penalties, available for willful violations of the law. And the civil penalties, it could go up as $500 a day, which is inflation adjusted. So I think it's almost up to $600 a day now, with a cap of $10,000 on that. But then there's also up to 2 years in prison for willful violations of the act. And that's causing a lot of people to get very stressed out because they're, notwithstanding the fact that there are FAQs released by FinCEN on how to comply and what to do, there are lots of scenarios that just haven't really been thought about, or clearly described by FinCEN. So, attorneys like us are getting lots of questions, in that respect.
Yeah, that's why we're having this conversation. Now, there's a lot of integration between the Canadian and U.S. economies, for example, Mexican and U.S. economies as well. Is this grabbing on, like, is this grabbing onto a lot of businesses, or what should we do? Should we go through the process of talking to a lawyer that has expertise in this area, not just a local that maybe does the odd business contract for you or a mortgage? Talking to a lawyer that has expertise and seeing if you are caught in the net, or is that the best first step, or what should we do as businesses?
Yeah, I think that is the first step. You're going to want to have, your corporate organization, handy and know where you, where your companies are, where every company in your organizational structure is, subsidiaries, and all that. And I would definitely recommend reaching out to sophisticated counsel that has background in interpreting and understanding US AML regulations and the like, because it could get complicated. There may be exemptions that apply to some, but not all of your entities. There, you could be potentially fully exempted. There are lots of different things that have to be analyzed and looked at. And another thing that would be a good first step is if you know that you have a US entity, say that you formed years ago and you haven't used it for anything, 5-10 years, but it still exists. It's still out there. It hasn't been formally dissolved or wound down. I would recommend thinking about winding it down now before January 1st, because if you don't, notwithstanding the fact that it hasn't been used for anything in years, that would get picked up by these pretty broad sweeping regulations, and you'd have to report based on that inactive entity that still, however, exists.
My perception here in talking to people is that this is like there's not to be messed with. Like there's sort of like this default we have where it's like, yeah, this won't apply to me. Like you sort of said this in terms of the exemptions, but be careful here.
Yeah, especially with the civil and criminal penalties, and we haven't really seen it been enforced yet. I think the FinCEN is still in the process of letting companies, really file and kind of populate their database and of information, and but I would expect that we will start to see some enforcements going forward, and you would not want to be caught up as any kind of example enforcement. So you should definitely look to comply. FinCEN's also made public comments where they suggest if you're not 100% sure if an exemption applies or not, to err on being over-inclusive. And of course, these are conversations to have with your board, your attorneys, but they are interpreting it pretty broadly and suggesting compliance.
Do they have the resources in order to handle this level of companies this potentially applies to? They're trying to go through this process of seeing if they have to comply or not.
Well, that's another good question. But the chances are they will focus, like law enforcement, often does, on areas, maybe industries or areas or things that they get flagged as red flags, and will focus their efforts there.
Does it create any potential legal or operational challenges for Canadian companies or Mexican companies that are trying to operate in the U.S. as a result of the CTA? Like, does it thicken the border, so to speak?
Yeah, you'll have to likely adopt more compliance, guidelines internally. A lot of non-U.S. companies, say Canadian or Mexican companies, will rotate executives, overseas or across the border here to the U.S. when they have a subsidiary or joint venture or some other operations in the U.S. And they may have short rotations, long rotations, but even that would trigger changes in filings to FinCEN just by the fact that you sent somebody else to be an officer of your U.S. operation, and you'll really have to have these procedures in place in order to make sure that you can comply and that you're up to date on your compliance. And there are of course other items like handling of personal identifiable information. You're going to have to start collecting this information, copies of passports, driver's license, dates of birth on people, and you'll want to make sure that you're complying with all local laws. So you'll have to also reach out to local counsel, in jurisdictions where you're collecting that information, be it in the U.S., Canada, Mexico, or from persons overseas that also are involved. So it really touches on a lot of things that will require a lot of thought to go into compliance and operational procedures to address all these items.
Yeah, well, agriculture is very much a cross-border business, livestock, grains, oil seeds. And so I think there's a number of our audience that is going to want to check and see what they have to do from a compliance standpoint when it comes to the Corporate Transparency Act. Adam, thanks so much for joining us here today, shedding some light on it and a bit of a rude awakening, so to speak, for a lot of us to check this out.
It was my pleasure, Sean, and thanks for having me.